This paper is CB bracket 1, for the 2027 bracket 02 in para 7, in the best interest. Well, we understand that this is a very controversial issue.
The administration is now saying that the best interest concept is already applied when there is a change of policy. But if you are proposing amendments to so many disciplinary, provisions, in the past, people have a concept of the best interest of clients. But if in case where you have agents representing the insurance company, how would they determine what is the best interest? Because they would have signed a contract. An extreme example would be whether or not best interest means that you don't charge a commission at all. We all know, of course, that's not possible. So this is using an extreme example to explain that this issue may actually arise. I understand that you'll be looking into this, and we will continue to follow up on this one with you. The issues arising from that is really a cause of concern for many. I have many questions, Chairman. I'll leave it to your decision. If you want me to pause at a particular point and give the other members their turn to speak, I'll be fine with that. I think you can raise all the questions you wish to raise, and I can knock them down. If the government cannot answer all the questions, then they can, they don't have time, then they can answer your questions in the second round. Well, okay then, Chairman, my first question is about best interest. I think this is one of the issues with which the trade is debating with the administration. Secondly, the appeal procedure and how we can further perfect that. And also in paragraph 8 of the paper, the new section 92 states that they also refer to Annex A. And the trade is worried about whether or not they need to make disclosures in respect of commissions. In F, under Annex A, the licensed intermediaries have to take necessary steps when they will need to disclose to the customers about any commission that they make. I think this is about investment-related products. Regarding disclosure of commission, I think we have many meetings with the IIA. The IIA had done a lot of work on this already. At a meeting comprised where more than 1,000 attended, the administration said that other than investment-related policies, they have no intention to extend that to life insurance. And this is what the government says in its paper. I hope the government can also spell this out more clearly and tell us what is its position. We all know that why the investment-linked products, there is a background to why there is a requirement for disclosure. But what about the commissions for intermediaries, or agents rather? And the government has indicated that it will not deal with this issue. If that is the approach, why is it that car salesmen don't have to disclose the commissions that they make? Does it mean that for any commercial act a person engages in, he will need to make disclosure? I want the government to ensure that this requirement will not be extended to other non-investment related products. The current amendment will make it convenient for you to simply require that investment-linked products should require that disclosure. Code of conduct will be accepted by the court as evidence, and the court will need to consider any compliance or non-compliance of the code. It also says that if the licensed intermediaries have failed to comply with the code, this in itself would not result in the intermediary being prosecuted in any legal proceedings. I understand that you will be issuing codes and guidelines, and I hope that the administration can explain this clearly so that members of the industry can rest assured. Could the government also tell us, explain a bit more about Section 9? That is, what do you mean by the intermediaries. Even if they fail to comply with the code, there will not be any legal proceedings. On the other hand, thus compliance with the code means that there are no problems at all. And Section 12, definition of improper behavior. In 12D, could you explain that? That is, and according to the IAA, that is contravention of a provision of the amended ICO, contravention of the term and condition of a license granted under the amended ICO. I'd like you to explain what do you mean by hurting the interests of customers. I have my concern here because in the next paragraph, in D, you say that if any act or omission is likely to be prejudicial to the interests of policyholders, or I think here you're talking about the relationship with the code. Does it mean the full compliance with the code would mean that it will be all right, and any violation of that would that be a criminal offense? Perhaps I pause here because I still have many more questions. Chairman, I think the concept of regulation is not that we want to create some traps so that people could be caught. The regulatory system at the moment has been set up with the purpose of ensuring that the licensed person will voluntarily comply with the codes. For any agents or any intermediaries, we will require such organization to appoint a responsible person who would be responsible for promoting self-compliance. Of course, we will need to also provide some guidelines for the industry. Regarding best interests, we must know that insurance involves a very complicated contract. In the regulation of insurance and also in the regulation of financial matters, we need to deal with the question of information asymmetry. That is, insurance companies and the insurance intermediaries, they must have a better understanding of the terms of the policy than the average consumer. So we must therefore protect the citizen. Otherwise, people will lose the confidence in the insurance industry. And this is not something that was invented in Hong Kong. Internationally, there is a IAIS, International Assurance Regulatory Association, which clearly, has explained why we need such codes. That is, the consumers and the policyholders must have confidence in the insurance industry. I understand that some insurance companies are already adopting, customer-focused corporate culture, and I believe this is going to be the mainstream culture. So what we are proposing now actually reflects the regulatory requirements for the insurance industry, and such requirements are very common internationally. Mr. Chen already pointed out that there is already this requirement under the self-regulatory regime. For insurance intermediaries, before they become intermediaries, they will need to attend some examinations, and the examination clearly would refer to the different roles by the insurance agents and the insurance intermediaries. Now, I also like to draw members' attention to the syllabus for insurance practitioners. Under Part 7, Paragraph 2, even for an insurance agent, if he were appointed by the insurance company, he should still, hold his customers the highest level of integrity, and that he must, abide by certain regulatory requirements. Of course, some people say, well, no, we are now proposing a higher threshold. Now, we must say that according to the bill, any breach of the code may not result in a criminal liability. I must say that once again, there won't be any criminal liability. There will only be a disciplinary process. All these requirements in the code of conduct would have to be, general principles. When it comes to implementation, we have to give the trade a clear guideline, and that is why we require that the IIA will issue such guidelines in the future. Members also asked a question about the guidelines. We stipulate clearly, we have stipulated clearly that when any rules are being promulgated, the regulator must consult the public. So there must be a process to consult the public before you impose such a requirement, because these regulations are subsidiary legislations. Mr. Chen also referred to the annex, namely the part about disclosure of commission. So actually this gives the regulator a lot of discretion to produce subsidiary legislation relating to the regulation of insurance intermediaries, and that must be put to the public for consultation. We've also provided some examples to show that there are already some regulatory requirements under the voluntary regulatory regime. Mr. Chen referred to investment-linked insurance products, and there are already guidelines for those products. That's one example, but it doesn't mean that for the entire we have any requirement for disclosure for all for commission for all types of insurance products. We do not have that intention at the moment. We have made this requirement now because for investment-linked insurance products, we believe that we need to further enhance protect the policyholders. Members also asked about the effectiveness of the guidelines. Guidelines and subsidiary legislations are not the same. Guidelines are not legally binding, it's not the law. Compliance with the guidelines or otherwise will not result in any legal liability. But I said earlier that in future, when an appeal has to be lodged to the court in respect of the conduct of an intermediary, the court will make reference of the code as evidence, meaning that a licensed person may feel that the IIA is wrong in imposing a fine on him, because in doing what he had done, he had fully complied with the guidelines of the IIA, and therefore he would use the guideline as evidence, saying that the IIA has required me to do ABCD3 and he has fully complied already. So the guideline will serve as evidence in court. Internationally, this is a very common practice, and I don't think Hong Kong is any different from other jurisdictions. I believe I've already answered Mr. Chen's questions, but I'll be happy to answer any follow-up questions.
I'll just follow up on the Commissioner's answer. Now, back to the point about the best interest. Now, on the one hand, we say that the insurance industry is complex, and it's unfair to simplify or resolve conflicts of interest in a very simplistic manner. I'm happy to hear that Commissioner, first of all, understands as well the complexity and the possible conflicts, which could be numerous. Well, because for ordinary brokers, well, they represent a number of intermediaries, so there isn't any controversy that he should act in the best interest of the policyholder. Now, the problem is this element of the best interest is backed by legislation, and it may have far-reaching implications. Now, if an agent signs a contract, it should bear in mind the best interest of his principal, and how to strike a balance if he should also act in the best interest of his client. Now, let's say if the broker works for 4 insurers, of course the agent should get the best protection for his client among the 4. And what about the products outside the 4 insurers? Well, the point is the operation of the industry is far more complex than any outsiders can imagine. You can have all the talk, you can say that this is the practice across the world, but this is irresponsible. Instead, a commissioner understands our situation, and she has really poured her heart into it. So first of all, yes, the industry's voice should be heard and the matter should be clarified by way of guidelines. Well, of course, it's best to do away with this phrase, but we understand the controversies, so at least it should be set out in the guidelines for practitioners to understand what or whether or not they have acted in the best interest. So my question is, when will the guidelines be ready? We're not going to threaten you to canvass your support. I will do it legally. As I understand that you have begun the discussion, and because in future, even after the legislation is passed, I hope the administration can keep an open mind on this point. Yes. Well, let me first of all supplement. In fact, in the bill, we have this provision. We understand very clearly the difference between an intermediary and a broker or an agent. Now, as an agent works in the best interest of his client, the insurer should not, on this ground, void the contract between the insurer and the insurance agents. So we already have a provision protecting insurance agents. As for the guidelines, as I said just now, in other jurisdictions, there are guidelines setting out in detail their requirements. The FSTB in January this year set up a working group on transition with participation by industry practitioners, and in February we started discussing with the industry on what should be included in this element of best interest in the guidelines, and examples of acting in the best interest and not in the best interest. And the FSTB also draws reference from other jurisdictions and give examples to the industry, and we hope to work with industry in preparing the guidelines. I am not the IIA, so I cannot issue guidelines on behalf of the IIA to be set up, but our work will be very useful. It will serve as reference for the IIA so that it can work on a basis.
Chairman, if I may also supplement, we expect that the IIA in future, after it has been set up, as we find in paragraph 9, will publish codes of conduct for the agents. After the codes have been drafted, all the preparatory work mentioned by the Deputy Secretary. After drafting is completed, of course, we must consult the industry. At that time, I'm sure there will be a lot of room for discussion as to whether or not the codes are detailed enough and exhausted enough, and whether or not the issues of concern for the insurance agents have already been covered, or would there be other issues which have not yet been included. And if so, then the members of the industry can raise the opinion, and then the IIA will only finalize the code after they've taken on board all the views expressed by the industry. The first response of the Deputy Secretary is that the best interest of consumers, if it should conflict with the employee's contract, then the contract with the employer would be void. I'm sure your guideline will be able to deal with this anomaly. So I've already expressed the opinion of the trade. Chairman, if you may allow me to ask another question in respect of Section 72. Section 68, and there is one point here. That is, in future, if the client knows very well that the agent doesn't have the authority and he still did discuss the insurance contract with him, then the company would need to be responsible. Now, before we have the new legislation, we don't have such a problem. If the person who signs the contract knows that the agent doesn't have the authority to do that, and he still signs that contract, then the contract is not binding on the insurance company. Could the administration, also tell us what is his position so that I can relate that to the members of the industry? We're talking about Section 60A, bracket 3, bracket 4, and bracket 4B. If you're not ready to give us an answer to today, you can let me know afterwards, so that even if it goes beyond the authority of the agent, the insurance company would need to be responsible. They're worried that if the customer knows very well that the agent doesn't have the authority, he will still, approach the agent and sign a contract with him. If you can't give us an answer today, you can reply to my questions in writing later on. And now I'd like to go to Section 14, disciplinary process. Again, this is very controversial. I think the debate is about a maximum fine of $10 million and 3 times the profits that has been made. I think I've attended many meetings with individual stakeholders and also, and I've told them that the government has no intention to cause them to suffer any losses. Actually, I've also gave briefings on your guidelines in respect of fines. And members of the industry basically knows the principle, namely that the fine will not be imposed at a maximum of 10 million. But they want to ask whether or not, let's say if the large company causes a major loss for a customer, then $10 million would be appropriate. For an ordinary insurance broker, then I don't think he can cause a customer to lose $10 million. So would you be prepared to consider a ceiling for the company and also for the individual practitioner? I understand that this is difficult, but could you tell us what is your position and whether you can consider providing smaller tiers of fines for so that the intermediaries can have the confidence. Let me answer the question about fines. We're well aware of the views of the industry. We have to, well, Mr. Chen already explained that. For insurance intermediaries, you're talking about a wide spectrum. We have individual agents, and we also have multinational insurance agents or companies, which could be even larger than that of an insurance company. So when determining the fines, we have taken on board the fact that the intermediary could span a very wide spectrum. In the law, we have stipulated that fines for an individual must be lower than that for the corporation, and if that's the case, we think there is a problem there. We need to also regulate the responsible authorized person. If an individual, breaches, the rules, does that mean that he will have to, pay a large fine? But sometimes the company may be very small, so the misconduct by a single individual. Of course, how much fine should be imposed, we have to consider the gravity of the offense. but the misconduct by an individual certainly, if it was less serious than that of a company. But in the law, we have a problem. If we need to issue fines, we have to publish guidelines. And in those guidelines, can we provide for the, differentiation? I'm sure we can discuss that with the trade later on. I don't quite understand Mr. Chen's first question. According to the existing insurance ordinance, perhaps I can provide a written response to Mr. Chenkimbao's question. Right now, the insurance company's ordinance already has, such a requirement. And Mr. Chen is asking about whether there's any discrepancy between those requirements and the requirements as proposed in the bill. Chairman, the Deputy Secretary cited the example of the MPFA. I don't think that is an appropriate example. The MPF is a lot simpler and the amount involved is a lot smaller. You cannot imagine a scenario where people complaining the MPF insurance agent, advising them to buy the wrong product. But for annuities and so on, the turnover every year is already 100 million. So the best ever and the best interest. These two expressions may result in legal liabilities which are not clearly defined. So please don't cite the example of the MPFA anymore, because the risk involved for MPFA is a lot smaller. Some people saying that the individual travel scheme is progressing so slowly because the responsibility is too onerous and they're only getting a commission of a few $100. But on the other hand, many people are actively selling new policies amounting to $100 million. We're only talking about life insurance here, and not counting the renewal policies and so on. So you really have to stand in the shoes of those who are selling policies, and also the insurance companies, and find out what are the concerns. Don't cite any examples for which when there are actually no real problems. I also like to talk about the code of conduct. The trade thinks that this should be removed, but I still think that is one way, one solution to come up with some guidelines so that people would not fall into traps. And I think this is the most constructive suggestion. I believe you'll do the same for the best endeavor. And secondly, I'd like to go back to Section 23 of the paper.
Independent appellate channel. An aggrieved person can appeal to the Insurance Appeals Tribunal, IAT, but we're not talking about this stage because it will be too late when the case reaches the tribunal, and there will be cost implications. We hope that the administration, since it has a professional team, well, the administration is saying that they can decide whether or not to refer the case to the professional team, and that professional advice may be sought. Now, what we want to strive for is this. Should all these cases be referred to the professional group for expert advice, or the expert group? What if the advice is different from the decision made by the IIA? Then I'm not saying that the decision should be overturned. I'm just saying that you should make the best use of the expert group, since it comprises experienced professionals, and experience of the experts in the expert group or in the disciplinary panel will not go to waste. If you appoint somebody inexperienced, somebody new, there may not be any consistency in passing penalty. I hope there won't be any waste of resources. I hope the administration can seek legal expert advice from the expert group. As for the process review panel, we understand that this is not for the purpose of reviewing any individual case, and Mr. Yu Si-wing cannot attend the meeting today. He has asked me to ask this question. That is to ask the administration to invite more industry practitioners to sit on this PRP. Yes. Let me first respond to the point about MPF being not as important as the insurance industry. Then I don't agree. Chairman, I'm talking about complexity, not importance. Well, in fact, in terms of regulation, it's much harsher. And we do have professionals from the sitting on the PRP. I must talk about the PRPs for the Financial Reporting Council or the MPFA. Both panels comprise professional practitioners from the industry, and the independent PRP for the IIA will be the same in the future. Let me tell you something about the design. In imposing disciplinary sanctions, the decision will be made by the IIA, and there is an expert group under the IIA. And if the IIA is of the view that it doesn't have the expertise to deal with a particular case, the case can be referred to the expert group. And because we know that the insurance industry is very complex, and even a practitioner within the industry may not be familiar with all the products. For example, a maritime insurance policy may be very specific, and we may need to engage experts in this field. The point is, there should be a clear body responsible for making this decision. So the IIA can only seek advice from the group. Ultimately, the decision will be made by the IIA, and the law sets out very clearly that the IAT, the Insurance Appeals Tribunal, can review a disciplinary decision if appealed against. So procedurally, it's very clear that the decision is to be made by the IIA. And I want to clarify that in imposing a disciplinary sanction, the IIA can seek advice from experts. But we need to strike a balance. The decision made by the IIA should be made in a fair and impartial manner, and it should not be subject to any interference or undue interference.
Chairman, I'd like to go back to Section 71. I'd like to ask whether we've discussed 64K and J already. We have a paper which is follow-up to our last meeting. Actually, it's the previous paper, but I don't think we've discussed that yet, or are we going to cover that later on? Chairman, if I recall correctly, at the meeting on the 21st of July, we have already given a written response. I can also give a simple response now. So you're talking about Annex B. Right? There we're talking about the existing insurance ordinance, which stipulates that the insurance companies and the insurance agent, companies with insurance companies cannot be confused as the same. That is for broker companies. A single individual cannot be the director of both companies. So the policy intent here is that insurance agents should represent the insurance company, and an agent, even if it were a company, can only accept appointment by 4 insurance companies, and the agent will represent the customer to look for the best insurance solution in the market. If a person were allowed to become an insurance agent, an intermediary, an agent and a broker, then there might be a loophole there. We already have this restriction now. In the new ordinance, we've changed the wordings, for example, the wordings like licensee and so on, so we've made some corresponding amendments. But some people in the trade agrees with the proposed amendments in the draft bill, while there are others who find them problematic. So after meeting with the industry, I hope they will look at 64J and K more carefully, and we'll be happy to hear whether they have any further views. And if you want us to make further refinements, we'll be happy to do that as well. Well, after you have given us your written response, we can still have more discussion. I understand that the COI have also said that it's not that we don't allow you to acquire the company, but you cannot participate in the management of the company. For example, in participate in the discussion about the strategy of the company, so on. I'd like to know under what circumstances will you clarify that? Only 2 days ago we were still discussing this. I explained to them that there's some progress made already. So perhaps you can, Commissioner, if anytime if the trade industry would require another meeting for us to explain to them the intent for the bill, I'll be happy to do that. The Deputy Secretary already told members that we are not saying that we don't allow an agent to acquire another or the broker of one insurance agent to acquire another insurance agent. As a shareholder, you can do that. That is a normal business transaction. You can even become its director. The only restraint is that you cannot take part in the regulated activities for that other company, such as the sale of insurance policies. So you cannot participate in that. So the way the industry is structured is that we have a distinction between agent and broker, and there are 2 approaches applicable to them. If you participate in the regulation and at the same time you keep acquiring insurance, agents, and you take part in these activities, then the whole system of insurance agents will be defeated, because you would actually, everybody would become brokers and there won't be any agents anymore. And in fact, in the course of our daily work, and given that the law ordinance is not very clear at the moment, indeed we have such a scenario. So the Deputy Secretary has told members that some companies in the trade have expressed a concern. And that's why this time we want to spell this out clearly so that everybody would know what they can do and what they cannot do, and that so that in order that there won't be any more gray areas. But it's not our intention that we don't allow them to make acquisitions or be the director of another agent, so long as you do not participate in its regulated activities. I think these are rather technical discussion, and I'll be happy to talk to the trade further. We've already had earlier discussions, but if anyone in the industry were interested, we can certainly have a further dialogue with them. Perhaps after the meeting I can take this up with Mr. Chan and make the necessary arrangements. I think it's almost time for us to wrap